Hello everyone, welcome to Court with Krissy, and welcome back to part 3 of the pro se DUI jury trial with Judge Johnson. We've got one more witness, and then this takes us all the way to the end, to the verdict. If you happen to miss part 1 and 2, links are in the video as well as in the description. I hope you like it. Court with Krissy is now in session.
All right, so the record should reflect that each of our 7 jurors is now present. You may be seated in their respective seats. And so at this point, I believe we're all done with testimony from the trooper. So you may step down and be excused. Anyone have any objections? No? People have another witness.
Paul Young.
Okay. Okay, sir, step on right around. Watch your step up that ramp. And you can raise your right hand to take your oath. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth? Thank you so much. Have a seat.
Thank you, Corinne. So can you please state your full name?
Paul here.
Thank you, spell it for us.
Paul, P-A-U-L, H-A-M-M.
Thank you. Mr. Ham, how are you currently?
I'm a nurse in Clarion, Oklahoma.
Okay. All right. And were you also employed there on December the 20th of 2023?
Yep.
And on that date around maybe 1:45 a.m. were you also on duty?
Yeah, I can't remember exactly, but assuming that if my signature is on the document, I was.
Understood. So I want to just ask a few questions, really just about your job when someone comes in with a suspected drug driver. First question I'm going to ask, are you trained in, I guess, pulling blood or, what was it before here?
Phlebotomy?
Sure.
I'm trained in phlebotomy.
Great word. Okay. How many times did you say that you have drawn blood from somebody who's been brought to the emergency room? Thousands. And how long have you been doing this job for?
4 years.
And is there a specific procedure that you said McLaren has you follow when someone comes in, or when I should say a police officer comes in with a suspected drug driver?
We follow I guess you want to say a T-sheet, follow the this shows the specific guidelines on how to draw the blood. So, let's say the correct routine.
Understood. And you would follow that routine when drawing blood, correct? Now, in particular with individuals who come in suspected of drunk driving, can you take me through and the jury through the process that you follow when a trooper or an officer or a deputy comes in?
Well, the first thing we ask is that sometimes it's a med clearance and a blood draw. Sometimes it's just a med clearance. So
What is a med clearance?
it doesn't necessarily mean that they've been drunk, but they are going to be incarcerated. So the jail needs, like if they've been in a small fender bender or, suspected of head or something, we have to medically clear them to be able.
Okay. So for a blood draw, where would you start, I guess, more with that?
For blood draw, we ask the officer, is it a warranted or is it voluntary? If it's voluntary, we would ask the person themselves, so you're best getting the blood. If it's a warrant, get a physical copy of the warrant, and it goes into our documentation.
Okay, would you pull blood from somebody that you didn't have a warrant for?
If it's voluntary,
If it wasn't voluntary and there was a warrant?
we're not allowed to.
So you need to see that warrant in order to draw the blood. Is that fair to say? Okay. Now, in cases where you would have a warrant to draw the blood, what is your first step with the particular patient or the individual who's there?
Identifying the patient. Then we just basically follow that T-sheet. There's where you can use it gives you where you've drawn from, the date, check box for warrant or involved voluntary, what we cleanse it with. Because if the patient is allergic to betadine, so it won't. So, we use the betadine that comes in the kit that the officer supplies.
Before you go further, would that be this kit right here?
Correct.
Okay, so the,
When you say this kit, what?
so the kit, the Michigan State Police, biological specimens kit?
Correct. They would, unseal it in front of me or whoever's trying to blood and person getting drawn. Then they pull apart the kit, the paper, the tubes for drawing in, and the betadine also.
What in particular gets handed to you?
The betadine and the tube.
And would you use the betadine like you said, from this particular test kit, unless obviously you had to use soap and water? Okay. Now, what do you do with these tubes when you first get them?
They get us there's a container in there that holds the two tubes.
Would it be this cardboard container?
I usually just set it right beside me. Grab the left one first. I always want to make sure because I want it. So I always grab the left one, other one. We will put the tourniquet above where we're going to draw from, approximately 2 inches. Finding a vein. Use the betadine, allow it to dry for, usually it takes about 10 seconds for it to dry. And then I got a container, take acupuncture, and then apply the tube to the back container. I try to get as much blood as I can. But usually about half full, both the out of the mouth. We invert the tube numerous times just to mix up. There's a substance in there. I don't know what it is, but we mix it.
What do you mean by invert?
Rolling it back and forth, up and down.
Okay.
Just to mix it up. It's actually whatever's in there. And then I place the first tube back. When I say first tube, I say it out loud, number 1, because there's a time to it also. So the officer can time is shown. And then the second tube, so like number 2, fill it, invert it when it's over done, back in face, and then get that back.
Okay, and does that, trooper typically put that back in the box in front of you?
Yes.
Okay. And the paperwork, do you have paperwork to fill out specific to McLaren? And is that done for every person you see that you potentially could be drawing blood from?
Every blood. So,
Understood. And in particular to anything that came out of this box, do you sign anything that goes into this box?
yeah, there's every paperwork, they have new kits out also. The paperwork's a little bit different, but we still sign. So on the new ones, the older ones are write my name and signature.
Whichever, I guess, testing
But the
kit
officer
would have your name.
tell us where, so they put our.
Okay, and you would only sign, obviously, if you had done the blood draw.
Correct. I'm sorry,
No, go
just to continue with, because you asked me.
No problem. Absolutely.
After the paperwork's been filled out, everything gets put back in the box and it's sealed.
Besides any copies that you might have, for example, of a warrant, or do you collect anything from this box? Is everything in that box typically given back to the officer?
Correct.
And is all of that done in the presence of both a person who's getting the blood drawn as well as the officer? And would this kit be resealed? We told we were, there's previous testimony of an integrity seal. Is that put back down in front? Your Honor, I don't have any further questions.
Cross-examination, Mr. Johnson?
How you doing? Been a minute since I seen you.
I don't remember this part.
Okay, but, you remember getting a warrant from?
I would have to look at I don't remember.
So you don't remember getting a warrant from the officer?
Like I said, I would have to see the paperwork, whether it was a warrant or it was voluntary, because I don't remember the incident.
Is there something you would like to show him?
I would like,
But you should have discovery.
Yeah, I do, but,
You could show him to refresh his memory.
I'll give, yeah.
Mr. Johnson?
Can I, hand it to him?
Yes. Show him what you're showing him. What are you showing him?
Warrant for the, blood draw.
All right. Does that help review that, help refresh your memory? Mr. Ham?
These all look the same to me. I mean, I've done thousands of these blood draws.
Okay, so you don't know for sure if you saw that particular warrant or not. Is there any paperwork that you sign off on that could refresh your memory or not?
The paperwork that I turn into our hospital or the signature on the chain of custody that I hand back to the officer.
No, did you have that, Ms. Mitch?
Um,
Signature on a chain of custody?
No, here it is, right here.
Okay, good.
It just says my printed name, so I say that it was done by me. I don't, it's not my signature. This might have been done by an officer.
Okay.
It is my name on this, but I don't.
So it doesn't
I didn't
refresh,
sign. I didn't.
it doesn't refresh your memory as to whether or not you saw a warrant. Okay, he doesn't remember.
Not in this
So
instance.
you don't remember seeing the warrant.
Not in this instance.
All right, so that means it's possible that you didn't see the officer close the box either, right?
If I would, if I could have my paperwork and
What's your paperwork look like?
it's just one piece of paper and when we.
Does it say the name of the hospital on it?
Yeah,
Is that something that's in Discovery?
it's in the medical record.
Oh, well, I don't know if we have that, but
like, Your Honor, I wouldn't have medical records, and I'm trying to see if, I mean, I printed everything I had and I don't see it. I was gonna double check, but I don't unfortunately have any internet right now. It's
Okay.
not connected to it, so.
oh, okay.
But you don't even know if the officer left the right box.
You don't understand.
I'm saying like, he sealed the box.
Yeah.
Gave it to him.
After he sealed the box, I left it.
Are you sure he sealed the box? You sure he left the box? You remember him?
Me, I remember his face. I don't know his name.
You don't remember me?
I don't remember. It's years ago. I do thousands. I see thousands of patients a year.
No further questions.
Okay. All right, anything else? No?
Regret, Your Honor. Mr. Ham, I brought you in specifically to kind of tell the jury how a blood draw works. You know, we don't assume that you're gonna know who someone is 2 years later. But, and I want to reiterate this, because I already stated it, if you did not have a warrant, which you have drawn blood.
If it was voluntary, yes.
Correct, if it was involuntary and you did not have a warrant, let's say if Mr. Like all that, and that's a simple question, if Mr. Johnson had told you he did not consent, he did not have a warrant.
No,
Okay, and that is procedure, would that be procedure with the hospital?
correct.
Okay,
It's like if a patient was unable to make decisions for themselves or unconscious, incapacitated, they have that.
okay. And is there any reason for you to refute the fact that there was or was not a warrant?
No,
Okay. But again, policy is you have to have that. Understood. No further questions, Jim.
Okay, anything else?
No further questions.
Okay, Mr. Ham, thank you so much. Next witness, if you have one.
Thank you, Your Honor. May Mr. Ham be excused for the
Yes,
day?
he may.
Thank you, Mr. Ham. Your Honor, the people would next call Mr. Ryan Giffler with the Michigan State Police in Toxicology unit. We'll grab this.
Oh, you're the only one here. Where's Jessica? You gotta come in. All right. Good afternoon. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
Yes, I do.
Thank you, and have a seat.
Nice to see you.
Whenever you're ready.
Sir, can you please state your name?
My name is Ryan Gifford, Ryan. Yeah, and that's forward.
Thank you. Mr. Gifford, what is your occupation?
I am a forensic scientist in the Toxicologist unit of Michigan State Police Forensic Science Division.
And how long have you been with the Michigan State Police Toxicology?
Since December of 2018,
And what are your duties as a forensic scientist with the Michigan State Police Toxicology Lab?
I test blood and other biological specimens for the presence and quantity of alcohol and drugs, as well as reviewing other work by the
And, excuse me, where do these specimens come from?
These specimens come from incidents, usually in a forensic or law setting. We receive them from the specimens we receive from agents often, and they are sent to the Lansing Laboratory.
Thank you. Just for you to approximate, again, it's just gonna be a rough estimate. How many samples have you yourself run in your career? Or I should say tested, not run, in your career with the Michigan State Police Toxicology Lab?
Several thousands.
Okay, so I'm gonna move on to your educational background at this point. Are you a member of any professional organization?
Yes, I am.
And what are those organizations?
I'm a member of two organizations, the Midwest Association of Toxicology and Therapeutic Drug Monitoring, as well as a national organization, the Society of Forensic Toxicology.
And have you received any other training related to forensic science or toxicology?
Yes, I have.
And what does that training entail? What have you attended?
I've had both internal Michigan State Police trainings as well as external trainings. The internal trainings involve the repeat analysis of already analyzed casework, making sure that my results are consistent with the original results. And then the external trainings are courses offered through the Indiana University Borkenstein School of Alcohol and Drug Impairments. And then also continuing education by attending meetings such as those by the MAT.
Thank you. Have you received any specialized training in the testing of blood to determine a blood alcohol?
Yes, I have.
And can you please describe that training?
The Michigan State Police training for analysis of blood alcohol involves repeat analysis of 200 known samples, as well as a laboratory exercise final exam, a oral final exam, which involves feeding the processes, the quality controls, the analytes, that sort of thing. And then it also involves attending some of the courses, such as the board.
Thank you. Again, rough estimate, how many times have you conducted tests of blood to determine a blood alcohol content or a BAC?
Several thousand.
Have you ever been qualified as an expert witness in a prior setting, prior trial, hearing, anything in the state of Michigan?
Yes, I have.
And how many times did you say you've been qualified as an expert witness?
Over 50 times.
And have you been qualified as an expert in analyzing blood or alcohol?
Yes, I have.
Would it be fair to say the same amount?
Not necessarily. Some of those would be for drug analysis, but I've always been qualified as an expert.
Is part of being a forensics, I'm sorry. Have you been qualified as an expert in both criminal and civil proceedings, or one or the other?
Mostly criminal, but a handful.
Do you recall, and just in particular, which courts you may have been qualified in?
Many around the state. I don't know.
Would they be, is it fair to say it would be circuit or district?
Both.
Both. Now, besides being qualified as an expert in forensic science, are you familiar with the Michigan State Police Lab's policy and procedures regarding blood sampling?
Yes, I am.
And are these policies and procedures essentially policies and procedures that you would follow on a daily basis through your employment?
Yes, I am.
Are you familiar with preserving the chain of custody of these samples?
Yes, I am.
Are you trained in such?
Yes, I am.
Are you familiar with the Michigan State Police Toxicology Lab's policies and procedures regarding maintenance of equipment?
Yes, I am.
And are you trained in them?
Yes, I am.
Mr. Gifford, were you able to review any materials or reports pertinent to this particular case with Mr. Thomas Johnson before coming into court today?
Yes, I did.
And do you believe that your testimony will be helpful in assisting the court to understand the facts of this case, that being the blood results?
Yes.
And will your testimony today be to a reasonable degree of scientific certainty?
Yes.
Your Honor, at this time, pursuant to MRA 702, I do move to tenure Mr. Gifford as an expert in the fields of both forensic science and toxicology.
Mr. Johnson, any objection to this witness being qualified as an expert? All right, then so be it. This witness will be qualified in the area of forensic science and blood toxicology. Is that what you said?
Yes, sir. Thank you. Now, Mr. Gifford, I'm going to draw your attention to January the 2nd of 2024. On that date, did you prepare a report regarding a blood sample that was taken from someone by the name of Thomas Johnson? And did you prepare that report yourself?
Yes, I did.
Is preparing reports a part of your everyday duties or your job as a forensic scientist with Michigan State?
Yes.
May I approach the witness?
Yes.
Okay, but I'm handing you what's been marked as People's Proposed Exhibit number 8. Please excuse the scanning lines. You recognize that document?
Yes, I do.
And what is that document?
This is a Michigan State Police Toxicology Unit laboratory report.
And how do you recognize that report specifically?
I recognize this report by the TX number or the internal laboratory number, the subject name, as well as my signature at the bottom.
Thank you. So is it fair to say that is your report?
Yes.
Now, Mr. Gifford, when a sample, let me do this. Your Honor, the people move to admit People's Proposed Exhibit number 8.
Any objection to this exhibit number 8? I think that's the toxicology report. Is that right?
That is correct.
Okay, 8 submitted, no objection.
Thank you. And may I privilege to this floor after I make sure that Mr. Gifford has had it for his reference.
Yes.
Thank you. Okay, Mr. Gifford, when a sample is received by the Michigan State Police Toxicology Lab, or this particular sample in general, was it on the 2nd of January or an earlier date?
It was received prior to the second.
Okay. Are samples that you receive at the toxicology lab tested immediately upon arrival?
Not immediately.
Now, do you recall, or does that report state when it was received?
Yes, it does.
And when is that date?
It was received December 26th, 2023 at 9 a.m. via interdepartmental mail.
Thank you. And again, is it fair to say you then presented or you prepared this report on the 2nd of January of 2024?
Yes.
Thank you. Now, Mr. Gifford, just generally for any blood sample received via interdepartmental mail, what happens when the Michigan State Police first receives that sample? How does it come?
The samples arrive in kits. These kits are supplied to every agency around the state by the Michigan State Police. The Forensic Science Division is part of the purchasing process for these kits, so all kits are the same from the same manufacturer. Inside the kits is some paperwork filled out for the submitting officer and agency, as well as preparation materials to conduct a blood draw and the specimen collection tubes and boxes. These kits are used at the time of the blood draw, sealed, and then mailed to the Michigan State Police Forensic Science Division Lansing Laboratory. We receive all the kits in the state, the Lansing Lab. When they arrive in the mail from the Lansing Lab, they're received by a technician back into the unit, one by one, sign the laboratory number and enter.
Thank you. And Mr. Gifford, is this done for every sample that is received from, or I guess, by the Michigan State Police Toxicology Lab?
Yes.
If there was anything wrong with the box, for example, if there was a seal that was broken, would that be notated in a report?
Yes, the technicians that receive the evidence are trained to get to that. It would be noted in the description as well as in the record.
Was anything with this particular kit for Mr. Johnson notated in that box?
No, it's not.
Now, Mr. Gifford, are you able to go back and access blood samples after you have written the report?
Not sure how you mean.
So when the blood has been analyzed and you write your report, are the vials stored?
Yeah.
Okay, you know how long they're stored for?
The vials are stored by toxicology for 2 years. However, post a directive from the Attorney General, we have been holding instructional evidence since mid-2020.
And would this all be in accordance with the procedures and policies that the Michigan State Police Toxicology Lab has?
Yes.
Thank you. Now, I want to briefly talk about the different roles within the lab. You are a forensic scientist, correct?
Correct.
Now, are forensic scientists the ones who actually test the blood?
Typically, yes.
Okay. In this instance, did you yourself test the vials of Mr. Johnson's blood?
Yes, it is.
So can you take us through the process? And I know I might have to stop you to get more detail because it's science. And if you could just take us through the process that you would start with.
Yes. So after the evidence is received, it's placed into a lab refrigeration unit and assigned for testing. The testing is conducted by the next scientist based on the schedule. I happen to be the next scientist up to receive this case. And in doing so, before I begin my analysis, I would read the evidence from the refrigeration unit. I compared sufficient information with laboratory number and subject name to make sure that I have the right evidence, case numbers, and then I begin my analysis. My analysis begins with first calibrating the instrument, making sure this is in condition before I begin any case work. After because the toxicology unit receives some of the samples, it'd be very inefficient to test one at a time. So the samples are tested in batch 70. There's 70 other cases, or 69 other cases along with this case. After I prepared all the samples and conducted the analysis on the instrument and interpret the data, generate reports. All of this information, both from the calibration and the controls, to make sure that the instrument is functioning correctly, reviewed by other scientists in the unit, as well as the data that's in the reports that I generate for these specific cases.
You said that there was an instrument used. What is that instrument called?
It is a headspace gas chromatograph.
And how does that work? Well, what is it?
So it is a instrument that works to separate analytes out. It does this by testing the air sample, the airspace, the headspace, above the liquid sample in a pump. Because of chemical properties and chemical laws, the volume and quantity and concentration of volatile substances such as ethanol in the airspace is proportional to the quantity in the liquid sample in the bottle.
Is this particular instrument generally accepted in the scientific community as a reliable method for testing alcohol content within a blood sample?
Yes, it is.
Is it the only instrument that can be used?
It is not the only instrument, but it is the only instrument in the Toxicologist unit is so.
Okay. And I know you've already done into that, but is it fair to say that you have tested samples before?
Yes.
Now, we move on to that. Now, once you have tested the actual sample with the blood, the next step was, I believe you say, to analyze the data.
Correct.
What does that mean specifically in layman's terms?
So first I examine the calibration and controls on the instrument. The calibration teaches the instrument various levels, and the controls run throughout for 70 cases to make sure that the instrument is operating correctly all of it. If those are all within order and meet acceptance criteria, I then begin looking with the cases to make sure that the cases meet acceptance criteria as well. There are 2 instruments, and the results from both instruments have to be agreed with.
So do you actually review the results?
Yes.
And you interpret them?
Yes.
Okay. Now, the report that you have in your hand that I will present to the jury in just a moment, you wrote this report based upon that.
Correct.
Now, on that form that's in front of you, your report in front of you, can you please tell the court and specifically the jury what that blood alcohol content was that you were able to interpret from this blood test?
Yes, I detected and quantified alcohol in the quantity of 0.112 grams of alcohol per 100 milliliters of blood.
Now, is there something called a level of uncertainty?
Yes, it does come with a measurement uncertainty.
What is a level of uncertainty, or what was it calculated here on this in this paper? Measurement
uncertainty is 9.6%. In this case, it was 0.001%. 0.011 grams of alcohol, 100 milliliters of blood, plus or minus. The uncertainty is a statistical mathematical representation of all the measurements of error involved in analysis. So the measurement of error for how accurate calibrator control is, by cutting equipment, all of those things are mathematically calculated into measurement.
Okay. Then we go back to that first number, so 0.112 grams of alcohol per 100 milliliter of blood, was that correct?
Yes.
Okay. Now, this level of uncertainty, we're gonna do math, and I went to law school to not do math, so we're gonna try really hard to get this right. So we've got the 0.112 level of uncertainty, so we're gonna, let's say, subtract 0.011. So if my math is correct, that's 0.101, correct?
Yes.
The lower level of uncertainty, so if we, let's say we have this 0.112, and then the level of uncertainty is the plus or minus, let's do plus the level of uncertainty, which is 0.011 to get to 0.123. Is that correct?
Correct.
That would not have fit. Is there a level of confidence as opposed to uncertainty?
Yeah, so the measurement uncertainty range that's generated, that plus or minus 0.011, is at the 99.7% level of confidence. That means that there's a 99.7% probability that the true value of the unknown lies within the range generated. Because it's a true unknown and it wasn't prepared and no value exists, this is a mathematical representation or window that, to a 99.7% probability, contains the truth.
Thank you. And may I reapproach the witness, Your Honor?
Yes.
Take this back to me and I'm gonna publish this to the jury. Now, Mr. Gifford, are you aware of what the legal limit in the state of Michigan is to operate a motor vehicle?
Yes, I am.
And what is that limit?
The legal limit is 0.080 grams of alcohol per 100 milliliters.
And is it fair to say that a 0.112 is over the legal limits?
Yes, it is.
Even giving that level of uncertainty, that plus or minus 0.011, would that still put this particular sample above the legal limit of 0.08?
Yes, it would.
Your Honor, I don't have any further questions, Mr. Gifford.
Cross-examination, Mr. Johnson.
How are you doing?
Good, how are you?
You say you're an expert?
Yes.
Okay, in your expert opinion, if somebody had some type of like disease or something like that, could that throw off the alcohol blood level?
Depending on the disease.
Okay, like diabetes?
It would not affect a blood alcohol result.
What would it, all right, what would spike alcohol level? Just alcohol, nothing else?
Correct.
And you said your uncertain level was what?
99.7% level of confidence. The uncertainty value is 9.6% or 0.011.
Still. And the legal limit is 0.80.
0.080.
All right, no further questions.
Better, I have no further questions, Mr. Gifford.
All right, Mr. Gifford, thank you so much, and you may step down.
Your Honor, may Mr. Gifford be excused?
Yes, he may.
Thank you. Your Honor, at this time, people have no further witnesses to call.
Okay. No other questions, okay. All right, so at this point in time, did you have witnesses that you wanted to call?
No.
Okay, you don't need to testify. You're not calling yourself? Okay, all right. This would be a very good time to take a break so that we can prepare for the final instructions and the closing argument. So.
All right.
Your Honor, I believe, I just want to make sure about the record, I'm being kind of handed back the toxicology lab report. Should I have the jury keep it here and they can take it back should they need it during deliberations?
Yeah, you can just leave it here and then if they ask for them, then they can receive them when we get to that point. Yes. this. So what we're going to do is take a recess. I'm gonna meet you both. You can be seated if you like. I'm gonna meet you both back in the law library to just go over some of these instructions. And then we'll be ready. Once I do that, we'll go to closing arguments and instructions. Oh, yeah. So, did you want to go off the record, Yes? We can go off both the live streams. Did I make you co-host? If not, you might not be able to turn off the live stream.
Oh, no, I did not.
See you in here.
Uh-huh.
All right, so we are back on the record here with the trial. Case number 24M00313SD, People's State of Michigan versus Thomas Johnson.
Michelle, Michelle's happening, people.
Thomas Johnson.
All right, after a brief recess to go over the jury instructions, I do think we're all set with that. So if there's nothing else, you ready for your closings?
Yes.
Okay, so let's bring the jurors in.
All right, you're
All right, you may be seated. And the record should reflect that all 7 of our jurors are present today, seated in their respective seats in the courtroom. Ladies and gentlemen, we are now going to proceed to the closing arguments. Ms. Mitch, on behalf of the people.
Thank you, Your Honor. Thank you again, everyone, for sitting here today with a long day. I'm gonna make it brief. I told you at the very beginning of this trial that it was a very straightforward case. The judge will go over the elements one more time for you, but just to kind of rehash it again. I've been required to prove 3 elements today. Beyond reasonable doubt, in order for all 7 of you, 6 soon to be, we'll be able to find that Mr. Johnson was guilty or is guilty of operating while intoxicated. That first element is that Mr. Johnson operated a motor vehicle, meaning that he drove the vehicle or had actual control of the vehicle. We did have Trooper Hinton testify essentially as to the stop itself, but you also have seen video that Mr. Johnson was in the driver's seat of this vehicle. He got out of this vehicle from the driver's seat. He was operating that vehicle. Element 1 has been met. The second element, the defendant operated a vehicle in a highway or other place open to the public or generally accessible to other motor vehicles. Again, there's been video to show that Mr. Johnson was driving down 8 Mile, highway open to the public, a highway that had other motorists on it. Were driving that day, who I would hope were not under the influence of a controlled substance, alcohol or drugs, right? People who went on the road that day hoping that there wasn't going to be a drunk driver on the road, but here we are. Again, ladies and gentlemen, that specific element has been met at those 2. Third one, the defendant operated the vehicle with a bodily alcohol level of 0.08 grams or more for 100 milliliters of blood. The exhibit is still right here in that lab report. Mr. Gifford from the toxicology lab came in and testified that when he ran Mr. Johnson's blood, he confirmed it with Mr. Johnson's blood, given all the chain of custody issues that we have that we went through to show that what came out of Mr. Johnson is what was in front of Mr. Gifford at the toxicology lab, that his level was a 0.112. And with that level of uncertainty, we were still above 0.08, with well above it. So in the eyes of most people, that element has also been met. Now, obviously, this is all up for everyone here to decide. But again, these elements have been met. A big thing that was testified to as well that Mr. Johnson may bring up is location, right? Eastbound 8 Mile, City of Detroit, County Point. Within rock throwing distance of westbound 8 Mile in the city of Southfield in Oakland County. The judge will also instruct you that this is proper, that this case can be brought in this court, because this court has jurisdiction, given law in Michigan. And I don't want you to put too much into that. It is a law, it is what we have to follow, and that is why it was brought here. Now, there's also going to be instructions given to you on a lesser offense of an operating while visibly impaired. We have certain levels of intoxication. Now, this is one below what Mr. Johnson is currently being charged with. Visibly impaired means that, well, let me say this. Visibly impaired only requires first two elements that we went over, that he was driving a motor vehicle and he was operating a motor vehicle and he was doing so on a highway open to the public. The third element, in particular to that charge, is the defendant drove with less ability than would an ordinary careful driver. Mr. Johnson was driving over 60 miles an hour down 8 Mile, a 45-mile-an-hour road. Trooper Hinson testified as to that. There is video to clearly show he was going over the speed limit. He was passing other vehicles. He was swerving in a lane to get into another lane. Didn't use a turn signal until the trooper had his lights on. All signals here of operating while visibly impaired. It's up to you to decide that's enough. Now, the people allege here that the original charge of the operating while intoxicated has been met. Operating a vehicle on 8 Mile. Open to the public. Blood alcohol level of 0.112. But again, if you find as a jury that those elements are not met beyond a reasonable doubt, there is that lesser charge you can consider. However, given everything today, I am asking that you find Mr. Johnson guilty. Again, ladies and gentlemen, Mr. Johnson made a series of choices on December 20th. My mouth is getting really dry. Talking all day. I'm sorry for that. He made a series of choices. He drank alcohol. He got behind the wheel of his car, and he drove that vehicle. He put not only his life in danger, but the lives of all of those people on 8 Mile and wherever he traveled before them, before Trooper Hinson. Not okay behavior. That's why we have laws for this. Again, I do ask that you find Mr. Johnson guilty, and I really do thank you. Respect that.
Thank you, Ms. Mitch. Mr. Johnson, on behalf of yourself, this is your closing statement.
How you doing? No, they always say, was that the people? Yes. Always want to go by the law. It says the law is right. The law changed so much. So, I proved lack of evidence. I didn't get no ticket. Reason why you pulled me over, I didn't write that. What do you mean you ain't right? That's what happened. Set up the street. But everything else come. And walking out, I got a bad leg, so what I'm saying, it's kind of hard for me to walk it out. I actually told him that the team wouldn't hear that. Oh no, you drunk. So, talking about 4 points. So that's what that is. Now, oh, another thing is, I see her. She still got a robe on. I felt I'm not guilty. That's it. Thank you.
Okay. All right. So, members of the jury, now the evidence and the arguments in this case are finished, and I will now instruct you on the law. That is, I will explain to you the law that applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of the case are, and that is your job and nobody else's. You must think about all the evidence, then decide what each piece of evidence means and how important that you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer or the defendant said something different about the law, then follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are and then to apply the law as I give it to you, and in that way to decide this case. Again, a person accused of a crime is presumed to be innocent. So this means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements, and the prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt, growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of facts and circumstances of the case. So when you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyers and the defendant's statements and arguments are not evidence. They're only meant to help you understand the evidence and each side's legal theories. The lawyer's questions or the defendant's questions to witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, then you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. Now, at times during the trial, I might have excluded evidence that was offered or stricken testimony that was heard, so do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use personal knowledge that you may have about a place, a person, or an event. To repeat once more, you must decide this case based only on the evidence admitted during trial. Now, facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. So, in other words, you should consider all the evidence that you believe. As I said before, it's your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. So you do not have to accept or reject everything that a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice or that you may have based on race, gender, or national origin of the witness. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyer or the defendant? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with other evidence in the case. However, you may conclude that a witness deliberately lied about something that's important to how you decide the case. And if so, you may choose not to accept anything that witness said. Or on the other hand, if you think the witness lied about some things and told the truth about others, then you may simply accept the part you think is true and ignore the rest. Now, of course, every defendant has the absolute right not to testify. So when you decide the case, you must not consider the fact that the defendant did not testify. It must not affect your verdict in any way. You should not decide the case based upon which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence that you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from a witness, Ryan Gifford, who has given you his opinion as an expert in the field of forensic science and blood toxicology. Experts are allowed to give opinions in court about matters that they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and the facts that he gave for his opinion and whether those facts are true. You should also think about the expert's qualifications and whether his opinions make sense when you think about the other evidence in the case. You have heard testimony from witnesses who are police officers. Their testimony is to be judged by the same standards that you use to evaluate the testimony of other witnesses. Now, the defendant is charged with the crime of operating a motor vehicle while intoxicated. You may also consider a lesser serious charge of operating a motor vehicle, well, while visibly impaired. But for operating while intoxicated, he's been charged with operating while intoxicated, either A, with an unlawful bodily alcohol level, and or while under the influence of alcohol. And to prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. To operate means to drive or have actual physical control over the vehicle. Second, that the defendant operated the vehicle on a highway or other place open to the public or generally accessible to motor vehicles, including any designated parking lots. Third, that the defendant was intoxicated. That is, that the defendant either operated the vehicle with a bodily alcohol level of 0.08 grams or more per 100 milliliters of blood, and or operated the vehicle while under the influence of alcohol. Under the influence of alcohol means that because of drinking alcohol, the defendant's ability to operate a motor vehicle in a normal manner was substantially lessened. To be under the influence, a person does not have to be falling down or hardly able to stand up. On the other hand, just because a person drank alcohol or smells of alcohol does not prove by itself that the person is under the influence of alcohol. So the test is whether because of drinking alcohol, the defendant's mental or physical condition was significantly altered and the defendant was no longer able to operate a vehicle in a normal manner. The prosecutor must also prove beyond a reasonable doubt that this crime occurred on or about December 20th of 2023 in the city of Southfield or within 1 mile of the city of Southfield. Because any offense committed on the boundary line of 2 counties or within 1 mile of the dividing line between them may be alleged in the complaint to have been committed and may be prosecuted and punished in either county. So the defendant also, of course, again, is charged with that operating while intoxicated, but you could consider the lesser serious charge of operating a motor vehicle while visibly impaired. And to prove that charge, the prosecutor must prove each of these elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Again, operate means to drive or have actual physical control of the vehicle. And second, that the defendant operated the vehicle on a highway or other place open to the public or generally accessible to motor vehicles, including designated parking areas. And third, that due to drinking alcohol, the defendant drove with less ability than would be an ordinary careful driver would. The defendant's ability to drive must have been lessened to the point that it would have been noticed by another person. It's the defendant's ability to drive that must have been visibly lessened, not the defendant's manner of driving, though evidence of the defendant's manner of driving may be considered as evidence of the defendant's ability to drive. As you consider the possible verdicts, think about the following. What was the mental and physical condition of the defendant at the time he operated the motor vehicle? Were the defendant's reflexes, ability to see, way of walking and talking, manner of driving, and judgment normal? If there was evidence that any of these things seemed abnormal, was this caused by drinking alcohol? You may also consider the bodily alcohol content in reaching your verdict. In that regard, was the test technically accurate? Was the equipment properly assembled, maintained, and in good working order when tested? Were the tests reliable? Was the test given correctly? Was the person who gave it trained properly? Did the circumstance in which any test was given affect the accuracy of any results? One way to determine whether a person is intoxicated is to measure how much alcohol is in his blood. There was evidence in this trial that a test was given to the defendant. The purpose of this test is to measure the amount of alcohol in a person's blood. If you find that there were 0.08 grams or more of alcohol per 100 milliliters of the defendant's blood when he operated the vehicle, then you may find the defendant operated a motor vehicle with an unlawful bodily alcohol content, whether or not the alcohol content affected his ability to actually operate the vehicle. You may infer that the defendant's bodily alcohol content at the time of the test was the same as his bodily alcohol content at the time he operated the motor vehicle. In considering the evidence and arriving at your verdict, you may give the test whatever weight you believe it deserves. The results of a test are one factor that you may consider, along with all other evidence about the condition of the defendant at the time he operated the motor vehicle. Now, I have prepared a verdict form listing the possible verdicts. There are 3 possible verdicts: not guilty or guilty of operating a motor vehicle while under the influence or with an unlawful bodily alcohol level. And if you all agree that the defendant either operated the vehicle with an unlawful bodily alcohol level or while under the influence, it's not necessary that you agree on which of these violations occurred. However, in order to return a guilty verdict, you must all agree that one of those violations did occur. And the third verdict possible is guilty of operating a motor vehicle while visibly impaired. So the verdict form will have a place to choose the verdict: not guilty, guilty of operating while intoxicated, or guilty of the less serious offense of operating while visibly impaired. Choose only one of those verdicts. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. When you go to the jury room, you'll be given a written copy of these instructions that you've just heard. And as you discuss the case, you should think about all my instructions together as the law that you are to follow. I think they're all in here. And the ones I'm reading right now are in the last tab here. When you go to the jury room, you will be provided with a written copy of these instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones and other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on the verdict. So in the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing to the court officer. If you want to communicate with me while you're in the jury room, please let your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, the lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. And if you want to look at any or all of the exhibits that have been admitted, then just ask for them. And that concludes instructions. And there is a verdict form, as I indicated before, on the front inside pocket of this notebook. So, okay. So this is the moment you've all been waiting for, the moment Mr. Roberts asked about earlier. Who is the alternate? This is the part that I really don't like because I've been watching you all, and you all, each one of you, have had, you could see you thinking, you've been considering the evidence, you've been watching the witnesses, you've even asked a question or two, and now I have to pick someone as the alternate. So you won't get a chance to deliberate. So we have this very sophisticated process. It's an envelope. I always count to make sure we have all 7. 1, 2, 3, 4, 5, 6, 7. So I'm gonna mix them up. I don't even look. I'm gonna put them back in the envelope, and then I'm gonna just keep mixing till I can't mix anymore because I just really hate to do this. Okay, I'm just gonna keep going for a minute here, and then I'm just gonna grab something. This is a lot of suspense, right? Okay, okay, got it. Survey says, oops, didn't pick that one. Pick this one. Okay, seat number 4, Miss Jessica Walton. Oh, I picked you as the alternate. Yes, ma'am. Well, it means you need to stay here for a minute because, yes. Nope. He didn't get picked, so he's got to deliberate. And so, what we might need, you never know what happens. Somebody might get sick back there and not be able to finish. So we'll ask you to step out for now and have a seat here. Don't discuss it with anybody just yet, because we could need you. Okay, and so now, court officers, do you swear that you will, to the utmost of your ability, keep the person sworn as jurors on this trial in some private and convenient place, that you will not suffer any communication, orally or otherwise, to be made to them, and that you will not communicate with them yourself, orally or otherwise, unless by the court's order, or to ask them if they have agreed on their verdict, until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict that they have agreed upon. All right, very well. Thank you very much. All right, here's the book. You need that.
All right, jury.
Don't forget your notes if you have notes. Okay, so the record should reflect now that we just have the alternate left in the courtroom, and everyone may be seated. Is it?
You want to stay here, go down.
Yeah, she can go down to the other room. That'd be great. Here.
Miss Jessica, come with me.
That way we'll keep her outside of the discussion, just in case we need her. But we will come and get you as soon as we can. Okay. So now the record shall reflect that all of the jurors, including the alternate, are outside of the presence of the court at this moment. Does anyone have any objections or comments with respect to the reading of the instructions, Ms. Mitch?
No, Your Honor.
I just wanted to see.
Reading of the instructions. Okay. Any other comment, Ms. Mitch?
Nothing from Mr. Lee.
Now, Mr. Johnson.
Yes, well, I would like to see all those numbers on that green papers.
We could show them to you. That's fine. All right. So what we're gonna do is we're gonna be in recess. It's about 5:53 or so. So we're gonna give them a chance to take them about 5 minutes or so to pick a 4-person. We'll give them till about 6:30 to see how they're doing. And if they say they want to stay, I typically don't keep them really late. I'll stay till 7 unless they ask to stay a little later. Okay. Any question? Don't leave the building, Mr. Johnson, because you can't get back in.
Yeah, I know they did that to me.
Okay. All right. All right. So we're going to be in recess for just a moment. And we'll be back live when we have some information here. This isn't even my turn to do. Here we go. It's number 24M00313 SD. This is People of the State of Michigan versus Thomas Aaron Johnson.
Michelle mentioned we have.
Thomas Johnson.
All right, and so we are here towards the end of our jury trial because we've just gotten a note from the jurors that they have reached a verdict. So without further ado, let's bring them in. And did we get the alternate in? Is she? That gave back to you.
You did.
Mm-hmm. Oh, yeah.
I have another one. You did. Yes.
He's on hunger.
All rise for the jury.
Where's the alternate? Thought you went to get her. I told y'all to get her. Chelsea. You may be seated. Okay, so we wanted to wait your arrival. You can be seated. Thank you. And so, ladies and gentlemen, we're back here on the record with this matter of the people of the state of Michigan versus Thomas Johnson. My understanding is that the jury has reached a verdict in this matter. Who's the fourth person? Could you please stand? Okay, and that would be Mr. Frank Lapierre. Mr. Lapierre, could you hand the verdict form to? Where's the instructions in there?
Yes.
Could you please read the verdict? Start from the top where it says, we, the jury, and
We, the jury, in the above entitled action, find the defendant, Thomas Aaron Johnson, guilty of operating while intoxicated.
all right, thank you so much. Would anyone like the jurors polled?
The people deny.
That means asking them individually. Okay, all right. So we'll grab the verdict form back from you, Mr. Lapierre. And what I want to say is thank you so much, ladies and gentlemen, for your attentiveness in this manner. You were very attentive. You listened and you deliberated, and you ultimately found in favor of what the prosecution requested. But this process would not have worked if you had not done your job and done it admirably. So we really appreciate that. And what we're going to do is release you from your jury service today. You will also be getting your jury service check in the mail, and also you will get a juror certificate in the mail as well. I'm going to ask you to wait for me. I will be right back to speak with you in just a few moments, and the prosecutor may choose to come back and talk as well. So thank you again for your jury service, and we will release you back to your waiting jury chambers back there. Yeah, you can go. And now the record shall reflect that each of our jurors, including the alternate, have just stepped out of the courtroom now. The court is going to enter this as a judgment of guilty by jury. What we'll have to do next is request a pre-sentence report for you now, Mr. Johnson. So we're going to send you down to the probation department like tomorrow when you come to pay your fine for the ticket. You'll go down to probation, tell them that you need a pre-sentence interview scheduled. They will schedule you a date for that so that they can interview you. That's a background report, and they will do an alcohol assessment test as well. Don't miss that interview because we can't sentence you without the report. Then we're going to give you a date to come back to me for the actual sentencing, and I'll use the report, the alcohol assessment, and any other information that you'd like to submit to me to determine what the sentence should be.
I have to go to Lansing today to finish his job.
Day.
Later, can I do it at a later time, like next week sometime?
So you can't go tomorrow?
Not tomorrow.
Well, I thought you were going to pay your fine tomorrow.
No, we're fine. It's only a civil infraction.
Okay, well, you need to call them tomorrow. Call them and say that you're out of town on a job, but you need to schedule a PSI, pre-sentence interview for your case. And they'll give you a date for that. Our sentence date is going to be
Court available April 15th at 9:30.
April 15th at 9:30 a.m. Yes, at 9:30 a.m. for sentencing. He's going to give you a notice for that. So you're going to be all set for today.
Okay, also, all right, yeah, I have to drop the name. So.
Well, I would, you should check, but bottom line is if you were here, we know you were here. So that shouldn't be a problem. Okay? Okay.